Hi, this is Lee from the Law School Toolbox, and today we are talking about everyone's favorite topic, legal writing, specifically 5 ways to keep your legal writing organized. And we have with us one of our fantastic tutors on the Law School Toolbox team who also happens to be a legal writing professor. So she's in the trenches with those 1Ls. And I'm really excited to talk about this topic that is so important yet causes so much anxiety for 1Ls.
Yeah, hi, my name is Mary Fran, and enjoying being a tutor with Law School Toolbox and also enjoying being a legal writing professor, even though I know it causes a lot of stress and you're not alone if you're in that boat.
Absolutely. Well, let's dive in because a lot of law students spend a huge amount of time worrying about legal writing, whether they've gotten the law right, whether they've included every relevant facts, and those things absolutely matter. But I think one of the things we're going to talk about today is that even strong law and solid facts, they just aren't all of legal writing because you got to communicate well and make sure your reader can follow your issues, analysis, and conclusion. So why don't you share with me a little bit about why organization is so important?
Yeah, absolutely. So organization is really what ultimately makes your legal writing usable. That's what allows judges, supervisors, and clients, whoever's reading what you're writing, actually understand your reasoning and trust your conclusions. So that's why I think it's really important to focus on practical, repeatable habits that you can use to keep your writing organized and easier to follow from your first outline to your final draft. And a big reason why I think it needs to be prioritized is that legal readers they don't just care about what you conclude, but how you got there. They need to trust that conclusion. And even correct analysis loses force if the reader feels lost along the way.
I think law students can start to think about this even when they're reading their cases, because some cases are really well written, some case opinions, and you're like, wow, they're taking me on a journey. I'm here for it, step by step, I've got it. And then some cases you read and you're like, I have no idea what's going on.
Yeah, that's such a good point. I was just talking about this with my students last night. I was encouraging them. There's actually features on Westlaw and Lexis that you can use to access memorandum that have actually been filed, and I was encouraging them read those and experience what it's like being the reader reading that. What works for you? What's effective? And try to use that in your own writing. And if it's not effective, avoid that in your own writing. Being a legal reader and an intentional legal reader can absolutely help you be a legal writer.
Yeah. And I also think it's important to remember that these formulas and this kind of style of legal writing is the beginning of you developing your own legal writing. I know that for me, when I went to law school, I was writing professionally, like people would pay me to write things. And then I really got smacked down a little bit in law school because it was hard for me to abandon my own communication style and switch to this very formulaic form of writing. I thought I had a better way to do it. And it took a bit before it sounded like me again. In the beginning, it just didn't sound like my own work. But by the end of law school, when I was writing more sophisticated work, I do think it did start to sound like my own voice. And I think you have to be willing to have this caterpillar to a butterfly moment around this stuff and have that mindset, because it can feel weird, especially if you're someone who considers yourself a good writer, to feel like it's all being stripped away.
No, absolutely. Legal writing is not natural. I have never met anyone who's just naturally good at legal writing. That's why it's called a practice. You don't really perfect it. You're just practicing it. But you're totally right. At first, it's uncomfortable because it's not your voice. But then once you master it a little bit more, you can find your voice. And that's when it can get really fun.
Yeah. Well, see, true legal writing professor, this is fun. Everyone, let's buckle in. Okay, well, let's dive into some specifics. So I think you wanted to start with audience and purpose. So share a little bit about why you think this is the starting point when thinking about organizing your legal writing.
Absolutely. So I'm sure if you have been at law school even for a month and you're listening to this, you've already heard audience and purpose. Those are vital because organization doesn't exist in a vacuum. Structure matters, but it only works if it's guided by audience and purpose. And that's the lens that you should really be using for everything that follows. Before you sit down and write, I would recommend pausing and asking yourself, who am I writing to? What do I need the reader to understand by the end? What do I want the reader to do or decide, if anything? Because legal writing is never abstract. You're not just like writing for the sake of writing. You're writing for someone for some reason, whether it's a judge, supervisor, clients, opposing counsel, and in law school, your professor. Your professor is your audience, even if your audience is always also like a fake judge or a fake supervisor or something. And different readers have different backgrounds, but every single legal reader is going to need some sort of logical order that guides them step by step through the reasoning, a predictable structure, a natural structure, and guidance through how and why you reached your conclusion. Professors, like I said, are part of your audience and often have clear organizational preferences. And it can be annoying sometimes because maybe they don't even realize that that's a subjective preference that they have. So really pay attention to recurring feedback and about structure and clarity that you receive from your professor. But yeah, so why I wanted to start out with audience and purpose before we get into a list of 5 concrete ways to stay organized is because organization, again, is how you serve your audience and achieve your purpose. It reduces the cognitive load by helping your reader follow your reasoning and reach an informed decision. That's something I always like to emphasize. When you're writing something legal, especially if it's complex, even if you're writing to a judge and you think they're the smartest judge that you've ever appeared before, reduce their mental load. Don't make them have to make any inferences. Just lay it out on the table step by step.
Yeah, I think Alison has this very old blog post from back when we started this business about like writing to your grandmother, like making your legal writing sound like you were writing to your grandmother. But I do think that there is something about that, that I think sometimes we get caught up in legalese and terminology and we think that the most powerful writing sounds incredibly sophisticated. But I have learned over my career that it is the cleanest writing that is the most sophisticated, the cleanest messaging, the most concise. Nobody has a long attention span anymore.
No,
nobody
so
wants
true.
to go down some verbose, dense paragraph, especially when you're writing to clients and you're doing professional emails. Even now, most of us read our emails on our phone. And if I see a giant long paragraph, I'm just like, ugh. And I'll often close it and not read it until later. Hopefully I do get back to it. But because nobody wants to read that, it's just not a time when we love density, right? That's not kind of how we're being rewarded. So really getting into that mindset of we talk about this with legal exams too, put yourself in the position of the professor reading this. It's the same. Would you want to get this email from your attorney? I'm somebody's client, right? I have a trust and estates lawyer that does my, I don't like getting long emails from them. I like short and concise emails with to-do items, it's you got to keep it in mind.
Absolutely. I think that's so normal. And so the most that you can control, even if it's super complex, controlling that, streamlining that, and making it as simple as possible. Again, you're a brilliant client to have. And so a lawyer might be thinking, she's a lawyer. She knows this. And you're the audience. And you're like, no, I want it as simple as possible. I don't want to spend any more time than I have to on this.
Yeah, I know. In fact, there was an explanation in a document they sent over about community property versus separate property in California law. And this document was clearly what they use, when they just sent it. And I was annoyed that I had to sift through it because it was canned. And I was like, oh, I wish they just deleted this section. I realized that they need to do that. But I just I don't know. I'm an impatient person. I just don't want to read an explanation of that stuff. But honestly, a lot of clients probably don't read it, which is a problem for another day. We can talk about that another day. Right. But I think it is a great reminder that, that, the audience is important, and you have to think about how people are reading. People are reading things quickly. Even your professors are often reading things quickly, because I'm sure as a legal writing professor, you get a stack of assignments. And I remember when I started teaching, the first time I got this stack of, exams, and then you realize you're just reading one after the other. I mean, it's a lot. You want it to be as easy as possible to get through.
Exactly. We're all human beings. We all want, I've never met anybody who doesn't want things to be their life made a little easier and more pleasant. So, yeah. Okay. But before we dive too deep in this, I feel like in this age of AI, we have to keep talking about this. And I was reading a post the other day somewhere about students using AI instead of practicing writing, and how we are like losing individual voices. And so I do think we need to call it out, because I'm sure that somebody listening to this is saying, like, we won't have to legal write at a certain point. And that may or may not be true. That's a complicated question, probably outside the scope of this podcast. But although I think AI has the power to create some scaffolding, or maybe even at some point, if you're allowed at your school, to do some proofreading, I still think that it's incredibly important that we still learn how to use our voice, even if it's supported by technology. So what are you hearing from your students in the classroom? Like, are folks feeling like this is a dying art in the age of AI? So I have heard that some people think, even like my job as a legal writing professor, that's not going to be a thing soon because of AI. But I think that having a human being able to at least, AI right now, as I'm sure a lot of people have been warned, is terrible for legal writing. It hallucinates cases. And that's not to say I think that's going to improve. Like, I think AI is going to be able to write better briefs in the future. But I think that what's important is humans and AI being able to work together, and you can plug it in, and you need to be able to know how to analyze the output. And I think that's why it's so important that we have humans with, human history, human knowledge, being able to monitor what AI is putting out. And as attorneys, legal writing is what helps train you to, and I know people hate it when they hear this, but think like an attorney. It's what helps you even for your exams. Your legal writing is, you're doing CREAC, you're doing IRAC, and you're not able to, use AI. As far as I know, most professors don't let you do that on your tort
Not
exam.
yet, at least. No.
Yeah. You're not going to be able to, in front of a judge, say, hold on, I need to consult ChatGPT. I didn't think to ask them that before preparing for this hearing. So I'm not naive, and I think that AI is like part of the future of legal education, but I think it's less thinking about how will AI replace attorneys, and more how can we work with AI to make things less expensive for clients and make our jobs less stressful. But you still have that. Being a lawyer is so much, even though there's so much formality behind it, it's still a very human career, a very service-oriented career. So I do think it's important to still absolutely learn how to independently analyze the law using your human brain.
I also have found that I'm already getting a bit bored by reading like email blasts that are just written by ChatGPT, and you can always tell because it's always got emojis, like a lot of emojis.
Oh, yes.
I love a good emoji strategically placed, but it's starting to get to the point, and maybe someday AI will be more individualized, or I know that some people are training it in their own voice and things like that. But I do think that there is still a place for, creativity and tailoring of narratives and the work that lawyers need to be doing. And so you can't manage the tech if you don't understand what the tech is trying to do. So if nothing else, you need to be able to understand the underlying function of what makes the legal writing perform well and do what it needs to do. And then, I'm all for streamlining. So, it is what it is. But I am not excited to have everything look exactly the same or sound exactly the same. I think that we'll lose a little bit of, like you said, the human part of practicing law.
Yeah, no, I completely agree.
Okay, well, now I've taken us off a tangent, but let's right the ship because this is about organization and I am not following our organization. All right, so let's talk now about our tips for keeping your legal writing organized. So what is your first tip?
Yeah, so tip number 1 is ensuring that you are organizing at both the macro and micro level. So the macro organization, that's sort of like your big picture. Readers expect documents to follow a familiar, predictable structure, especially judges are going to expect that a memorandum of law is going to have certain headers depending on what sort of memo in support of a motion it is. So that's really just macro level refers to the overall structure of the document. So standard components of the document, that could be something like questions presented, facts, discussion, conclusion, and the order in which those components appear. If your professor or supervisor provides a template or sample, follow that very carefully because templates signal a reader's expectations. But more importantly, if your professor or supervisor provides specific organizational instructions, those are explicit requirements and not suggestions. And why I'm really trying to hit that point home is that ignoring those instructions can signal right off the bat that you are not engaging with the assignment as given, even if that's not actually the case, because your professor or supervisor is going to open the document and before they even start reading, see, why didn't they follow, like, this? It's kind of simple. I wanted you to have headers for introduction and discussion. And even if that's not the case, you worked really hard on it, that right off the bat is going to make your reader think, oh, they don't care as much about this writing. I can't trust it as much as I want to trust it. But beyond that, predictable structure helps readers. That helps them orient themselves to what section they're reading and focus on your reasoning instead of having to figure out for themselves where they are in the document. So if you have your introduction and then all of a sudden you start going into your facts, even if it's less than a second, without that facts header, that's making your reader have to do that little extra step of saying, oh, okay, I guess I'm reading the facts now. And yeah, so when macro organization is off, even strong analysis can feel confusing or scattered for a reader. And then micro organization, that refers to the paradigm that is really just getting thrown at you repeatedly, frameworks like CREAC or IRAC. That's what I'm talking about when I'm talking about micro organization. Because legal readers also expect analyses to follow a recognizable analytical framework like that. They need to be able to see what the relevant rule is, what that rule means, how it applies to the facts, and what conclusion should follow. Even when you're getting into persuasive writing, which I know a lot of students are doing right now in their second semester of legal research and writing, but even then, those frameworks don't disappear. They just serve a persuasive function. The order can shift. Maybe certain sections receive more emphasis than others. You can group arguments together strategically to highlight strengths and manage weaknesses. But even within that flexibility, the core components still need to be present. Because if you skip a step and you start applying the law, the facts to the law before you say what the law is, that's going to make analyses feel conclusory. It'll make your reader feel like you're kind of just writing based off of vibes and not the law. You still need to really ensure that you are walking your reader step by step through your analysis. And I mentioned, in persuasive writing, you can get more flexible. This semester, your second semester, you can definitely become more flexible. But you really need to understand and master the framework first. Then you have enough knowledge to make intentional choices about emphasis and sequencing. But until you feel really comfortable with it, CREAC and IRAC, those sort of frameworks, they provide you with a foolproof structure to help your reader follow your reasoning and make sure that you're not missing any steps along the way.
Oh, yeah. No creativity in this one, everyone. You just need to follow the directions. I really didn't realize how much of practicing law is actually following directions. I mean, it's like a
Yeah,
lot. And if you don't follow directions, there can be massive consequences in your legal practice. So if you are not
absolutely.
someone who likes to follow directions and formulas, then you better figure out how to create some scaffolding for yourself, because it's a huge part of practicing law is like doing
Absolutely.
things in the way that somebody asks you to do them.
And
Just,
and taking the bar too. I know
oh
you're
yeah.
super aware of that right now. You're in the weeds of next gen, but not following the instructions, you could have a brilliant answer to one of the
Oh
questions,
yeah.
but if you're not following the instructions, you might not get any points for it.
And this has been a struggle for students over the 15 plus years I've been helping people for the bar. You know, when you get a performance test. So for those who don't really appreciate it, there's a part of the bar, even the next gen bar, that's called a performance test, which includes kind of a legal writing assignment. And basically part of it is they're just testing whether you can follow directions, because they might say something like, do not include a statement of facts. And I swear, folks, people will still include a statement of facts because you've got adrenaline and you're like, but it needs a statement of facts. And they will not give you points for it. And then you have lost points in another section and you may fail the question because you didn't follow the directions. I mean, it really gets to be that basic sometimes. And in these legal writing classes, in this beginning of your law school career, is such a great way to train yourself to get used to following the directions, whether you like them or not. If you think that the rules around the headers are silly, too bad. That's just what's
Yeah.
expected. You know, you got to
No.
figure it out.
Such a good point, because I do think, and I can say this because I felt this way when I was a 1L. I was like, I'm a good writer, I know better, but no, you've got to be a humble student, and you know, a judge, once you're practicing, a judge not going to appreciate you saying, well, no, I know that you gave me those instructions, but I actually thought this way of doing it would be better. Like, that's just never
Yeah.
going to work. So you just
No
need to
judge,
flush
no
that out of
boss.
your system. Yeah.
No.
Yeah.
Yeah, because you are still like the least knowledgeable, or you have to get to a certain point where your tone and your preference will be what matters. But usually that's not the beginning of your career. Usually
Right.
you start out having to adopt someone else's preferences or rules, you know, and in the legal profession, often you are just at the mercy of whatever the court prefers. And I love your point of going onto Westlaw or Lexis and trying to read pleadings or read motions. I think it's so important. I felt really lucky that there was some pretty big Supreme Court cases that came out right in the beginning of law school. And so, you know, we would all nerd out and read them. But I had a real aha moment when I read one of them, because I do remember thinking, oh my gosh, they're IRACing. Like I just,
Oh.
it was like this famous filing by these amazing constitutional lawyers. And I'm like, oh my gosh, this is IRAC. You know,
That's
it
amazing.
seemed so silly in the moment.
Yeah.
Now, and at this point in my legal career, I'm like, well, of course, everything is IRAC'd. Even Supreme Court opinions are basically IRAC'd in a lot of ways. But I think that it helps you get used to the idea when you start to see, you know, writing that's happening right now, like the people who are shaping the legal profession right now are still relying on these structures. And that's why this macro and micro organization is so important. And you just have to release your desire for creativity. This is just not a place where you get to be creative.
Right. No, exactly. Unfortunately. And
I
as you
mean,
still find your voice, you can
yeah.
still find your voice. You can still have fun with it. But yeah, what's the point of writing something if it's something that your reader's gonna feel lost reading? And you know, what's the point at that point if you're not gonna achieve your purpose because your reader doesn't even understand what you're talking about?
No, in legal filings, you're doing like a game. It's a dance between parties, right? It's like where you do need to play by the rules of the game. And the rules of the game are that these are kind of like rules of engagement, right? We write in a certain way. Judges expect to see certain things. You were a clerk. You saw like I'm sure, a wide variety of documents come over your desk, but they were probably somewhat similar, or I hope they were.
Yes. No, and that's like, as clerking for a judge, you know, I would be so relieved when I'd see that a certain attorney submitted something, because, you know, that you build a reputation, and Whether you're a clerk who's helping draft an opinion, you're like, oh, this is someone whose writing I can trust. If I look at a case that they cited, I can go look at it and it will say what they say that the case says. And maybe their brief will help me in drafting the opinion. Like that, especially when you're writing to a judge, that's a great way of thinking of it. How can I write this so that it makes the judge easy to write an opinion in my favor?
Yeah. I was really lucky that one of my jobs out of college is I did political PR. And one of my jobs was writing things for, I basically was a ghostwriter.
Cool.
I wrote like op-eds to go to newspapers, and I wrote stuff for my boss to present to clients. And I was very fresh out of undergrad. I was very proud of myself for all of my undergrad work. And the first thing I took to my boss and laid on his desk, I was like, here you go. And then it came back and it was completely red. Like it was literally completely red. And I just remember standing there, little 22-year-old Lee standing there, and I was just kind of destroyed. And he just looked at me and he said, I'm not saying it's not bad, but that's not how I like my work done. Yeah. He's like, so you need to learn how to do it my way. Yeah. And I have to say, Brandon Castillo, if you are listening to this, I'm sure you're still practicing somewhere, but that was a huge gift to me, was just to look at me and say, like, this isn't about the quality of your work. This is about what I need from you. And that was a huge gift as a 22-year-old starting out in my professional career, to just have to learn that lesson, that it really didn't matter what I thought was the best work. It was really what my boss thought it was the best work. And I think in legal writing, it's about the judges thinking it's your best work. It's about clerks trusting you. It's about opposing counsel. When I was practicing, I remember getting some motions in limine that were just like horribly written, and it's just, you get them and you're like, oh, this is going to take me forever to double check all this work and find the mistakes. You can make a game out of it, but still it is your professional reputation, and it behooves you to remember that and think about the purpose of that writing. So I have to thank that very first professional job for teaching me that very important lesson.
Yeah. And being able to implement that feedback too that can be super hard. That could be a whole other podcast, how to implement the feedback that you're getting. But that makes a world of difference too. Like,
I'd like to say I took the feedback gracefully, but that's my not 22-year-old revisionist history probably. I'm sure my little ego was a little bruised, if I had to be honest, but it's so long ago now. I mean, I'm just a little bit over 22 now, as you can imagine.
Yeah. It was 3 months ago.
It was like 3 months ago. I mean, no, 3 years ago. But anyway, but it is important to look for those moments and just remember kind of what the point of this work is. I think that is important. If you enjoyed this video, please take a second to give us a like and leave us a comment, and be sure to subscribe to our channel so you don't miss any future content. And please stay tuned for the next video where we continue this conversation in part 2. If you have any questions, feel free to reach out to us via the contact form at lawschooltoolbox.com.